morning. Welcome to my channel, Alternate Juror. Oops, I am gonna mute that there for just a second. That'd be me. Had to make sure everything starts up here. Apologies. Um, that's been a Monday already. No doubt about it. That little thing right there. And earlier today, I went to open the drawer on my desk and completely pulled the handle right off. So, yeah, that's how my day is going so far. So great. Good morning, Bree. I do not envy what you are doing right now. She's at the dentist, so. Ugh. All right, so today's gonna be a really pretty short stream. I don't have any trials right now. I don't know if I'll do any before the end of the year because I haven't seen anything coming up. So we're gonna do a they had to reschedule. Poor thing. We're gonna do a quick update on Jessy Kurczewski. I did not stream this trial on Rumble, so give you a quick update for those of you on Rumble, if you did not watch this trial, Jessy's from Wisconsin, Waukesha. Probably no surprise there. The other famous person from Waukesha, Darrell Brooks. You know, the guy who ran over everybody in the parade. Be 2 years ago this past November. He represented himself. It was a great trial. Super great. I've never seen anything like it. And I really don't want to ever again. It was horrible, awful. He's awful. And he's right where he needs to be. Jessy, same judge, Judge Dorow. Like Judge Dorow, she likes to keep a very, very clean record. So she takes a long time because she does not want appellate issues. And I'd say she has very few. So Darrell Brooks had Judge Dorow. Jessy also had Judge Dorow as her judge. Jessy was convicted ultimately of unaliving her so-called friend, Lynn Hernan, with Visine. So tetrahydrozoline is the ingredient in Visine that if you take too much of it, it will kill you. Jessy's attorney, when in his opening statement, made this statement that nowhere on earth has anybody ever died from tetrahydrozoline poisoning. I knew right away that was incorrect, and I wish he had never said that because I had already, I knew of a case that a woman, she admitted that's how she took out her husband, was with Visine. So I knew they were going to hammer that, and they did. Jessy also was convicted of stealing money from Lynn. The state said it was around $350,000 or something like that. The jury didn't find her. They found her guilty of less than $100,000, but more than $10,000 on 2 counts, which I didn't understand because I think the state proved that one. My problem with this case from the get-go, like saying Jessy did this, was Lynn was really sick for a really long time. And so when Jessy found her, the police came, everybody that came, first responders, EMTs, police, fire department, whoever, everybody that showed up processed that scene as a self-deletion that Lynn had chosen to exit. And so we didn't have pictures of things that we kind of needed pictures of to say that Jessy staged that scene, because they didn't take pictures of what was in the trash can, was because Lynn was a known drinker, and Lynn did use eye drops. However, the bottle of eye drops that was found on the nightstand next to Lynn is a brand, I think it was Theratears, that does not have tetrahydrozoline in it. So, oops. But my whole thing is I wish they would have had pictures of the trash can. What was in the trash cans? Was there bottles of Visine, because I think the state said that it was like 6 bottles of Visine, which I think in the police interview, Jessy, that's where that number came from. Because I kept wondering where that number came from. How'd they know that if they didn't have anything? There was no Visine bottles found in Lynn's apartment, supposedly, because we didn't have pictures of the kitchen trash can, the bathroom trash can, nothing that Lynn could have maybe spiked her drink, threw away the bottles, and then proceeded to ingest the Visine. So I was kind of like, well, I don't know. Probably more likely than not, with the theft, Jessy did it. Then Jessy, we're going to hear, this is what we're going to hear about. She was supposed to be sentenced last week. Before the sentencing, her attorneys both of her attorneys filed motion to withdraw. They don't want to represent Jessy anymore. The reason they don't want to represent Jessy anymore is because a letter went to somebody who was smart enough to go straight to the prosecutor with it, saying it was basically Jessy giving this person instructions of how to make a voicemail of, quote unquote, Lynn, admitting, sorry, you're going to find me this way. Like, she said, nobody's has Lynn's voice on a recording, so nobody's going to know what it sounds like. It's been 5 years. Was telling them how to do all this stuff to make it, and then, that Lynn did it herself. One thing that Jessy tried to stand on in court was that Lynn was supposedly feeling guilty because Lynn had given her mother Visine and caused her passing. So she couldn't live with that. So that's why she did it to herself. Jessy is still standing on that. In this letter that the state has a hold of, it's on the back of the notes that Jessy took in court. Jessy took a ton of notes in court. 37 pages is the length of this letter. She insinuates, excuse me, that her attorneys are in on it, that her attorneys know about it, and that her attorneys won't tell. So her attorneys aren't going to go down with her. She's already convicted. They're going to save themselves. I don't believe, I am so sorry, that her attorneys know anything about this at all. I think it was all Jessy. She's going to deny it. She's still, give me 1 second. Well, okay. So she's still holding on to the fact that she's trying to get that story out there that Lynn did this to her mom, therefore Lynn did it to herself. She is standing firm there. You can't prove that at all. There's nothing to prove that Lynn did anything to her mother. So I'm going to play last week's hearing because Judge Dorow comes out. She has to hear the attorney's motions first. She's not super happy with the attorneys. I heard a little bit of that, but I was busy. I was in the middle of stuff because I wanted to know if I was going to need to jump on and do a stream of her sentencing. Well, spoiler alert, sentencing did not happen. Not sure when it's going to happen now. So we're going to hear the motion, and then I have not heard this yet, but I know Jessy speaks to the judge. I know she tries to interrupt the judge. Just a note, don't do that. Don't ever try to interrupt the judge, especially if you're sitting there as a convicted unaliver, theft, thief, whatever. She did so much. She did so much. She honestly thinks she is the smartest person in the room. And if you haven't heard of Sarah Boone, I'm going to probably try to do a few things about her. She has been supposed to be going on trial for like a year now. But she's a mess. She is sitting in jail in Florida, accused of playing hide and seek with her boyfriend and putting it wasn't really hide and seek because you locked him in a suitcase. So you kind of knew where he was. She locks him in a suitcase. She allegedly throws that suitcase down the stairs. So he's in that. He lands upside down in the suitcase. She takes video of him. He is pleading for his life in that suitcase. He is telling her, I cannot breathe. Like, Sarah, please let me out. And she is laughing, taking the video. And, you know, there's allegations of domestic violence and everything between the two of them, both sides. But she is laughing at this video. It's crazy. But when she does her police interview, she basically tells them, like, I'm smart. I'm super smart. I'm smarter than all of you. So Jessy and Sarah, they should become pen pals while sitting in, you know, behind the bars. They're going to be sitting behind for the rest of their lives. And they can talk about how smart they are while they're in prison. And I just don't think they'll get it. I just think they'll think they're still so smart. So we may do that Sarah Boone video. It's creepy. I mean, I don't even know why she's even fighting it. She cannot hang on to an attorney because she's horrible. Well, excuse me. She's so smart. She's so smart. She's so smart. She's stupid. So let's get into the other smart person, Miss Kurczewski, and bring in, I got it set up right where Judge Dorow is coming in. And everything should be turned up. I have checked. But with things that have happening to me today, who knows? Who knows? I have no idea. All right, here we go.
Court will call State of Wisconsin versus Jessy Kurczewski, 21 CF 885. May I have the appearances, please?
Good afternoon, Judge Randy Sitzberger, Abby Nikolai, and J.J. Crawford for the state.
Let me know how that sound is, because it's not blasting in my ears like it usually is.
Pablo Galaviz and Ms. Kurczewski.
Although scheduled for sentencing today, late last week, the court received the first of 2 motions to withdraw from the defense team. Since that time, I've also had a response filed by the state, and then a response to that filed by Attorney Kukler's office. This, of course, all followed on the 30th, the filing by the state of what it labeled as sentencing materials. Now, I've had an opportunity to review those sentencing materials. Today, in preparation for that, I did ask my clerk, Teresa, to send an email to the parties indicating I wanted to review the original documents. I thought that was important given how those documents were described and what is at issue with the motions to withdraw. The state did that. Those were dropped off at my chambers initially, and I just want to make a record of this. All 3 of the state's attorneys and the 2 detectives were there, and I indicated I wouldn't talk to anyone without defense being present. I thought that would not be proper, and they indicated they understood. It's my understanding that there was an attempt to get a hold of both Attorney Galaviz and Attorney Kukler, and they were not available, and so they all left, and I indicated I'd let them know when I was done reviewing the documents so that they could go back to them. They were in a large paper bag, very apparent to me that it's being maintained as evidence. All of the individual pages were in
I have everything up as loud as it will go.
Both sides, and was able to see
what I can do.
And I'll get confirmation of this, is the original envelope the state received the documents in. Anything the state would want to add to how I've described the receipt of the materials?
The only thing I would add briefly is that I did personally call Attorney Kukler. She answered at her office and said she was very busy and would not be able to make it, and that she was okay leaving the documents with Your Honor I then tried to contact Attorney Galvez and got his voicemail, but given the timeliness of it, we chose just to leave the documents with you and leave, as you stated.
All right. Attorney Kukler, since
Is that any
you
better?
were contacted, is there anything you would want to add to the record about that?
No, thank you.
I think it's important that the court obviously address this motion before proceeding in any fashion with sentencing here today. I have some questions. I don't think, at least at this moment, I have an adequate factual record to really make a determination. Both Attorney Kukler's office and Attorney Galvez filed a motion. There's some reference to ethical considerations, but none have been identified. I've done my homework. I've very meticulously gone through my Supreme Court rules, and I think I've identified what might be potential issues or provisions of the Supreme Court rules. But I think it's important to note for everyone here, for Ms. Kurczewski, for the victim, for both parties, for the public, that motions that are brought before a court must comply with 80201. And I don't think any of these motions do. There's certainly no affidavits that have been filed. There's all conclusory statements that are made. I have denied many motions over the course of my career for failing to state a claim upon which relief can be granted when a litigant, whether pro se or by an attorney, doesn't present the request in a proper way. Now, it's pretty clear to me that the parties have responded to those filings, the state filing first and then one in response, and given the nature of what's contained in the 37-page document, I have an idea, but I still need the defense attorneys to put forth a very particular basis. You could have filed an affidavit under seal if there was a concern. It should not be left to.
Okay, so I've tried to make this as loud as I possibly can. It's them. It's them, not me. Also, if you don't know Judge Dorow, she can recite statutes like no other person I have ever seen. And that's what she wants. If that's what's supposed to be cited, that's what you should have done. That's what you better do. She is very, very, very by the book. I'm not saying that's a bad thing, because it's not. I don't think it is.
To the court to guess or to assume what ethical prohibitions or ethical requirements you believe are at issue. The only thing, for example, Attorney Kukler, in your motion from your office is that it says professional considerations mandate. So what professional considerations mandate and what offer of proof can you provide to this court that, of course, is consistent with your ethical obligations? And when you address that, I need to also know to what extent you've discussed this with Ms. Kurczewski and what position, if any, she has regarding the request. So I'll start with you and then I'll turn to Attorney Galvez.
I did have a conversation with Ms. Kurczewski by video conference or telephone conference, one or the other, and did explain it to her. And it's my understanding that Attorney Galvez also discussed it, and she does not object to the withdrawal. The court, if you've seen the filings, you can see that there is an allegation within the, well, okay, taking one step back, when I was provided with copies of those documents and observed the originals, I was informed by the state that they believed that these documents were not mailed, but were drafted by our client and somehow taken from the jail and dropped off at the person who the envelope is addressed to, dropped at her house by somebody, that they didn't arrive there by the mail. And the suggestion within the documents is that, and the court, of course, could read that there's a request, and I'm not saying that these documents were drafted by Ms. Kurczewski, but the state alleges that
There's
they
an
were.
allegation.
They allege they were. And if so, Ms. Kurczewski has requested that this person who received this envelope that was dropped off at their home engage in what would be, I would say, illegal behavior.
To put it lightly.
And the suggestion also is that, without naming the attorney, that her attorney supports or made the reference to the attorney supports this request by Ms. Kurczewski. And the attorney's not named.
Good morning, Kim. Again.
That I know of on the case. And so,
What ethical provisions do you believe govern this conduct that you believe creates the conflict of interest?
Well, I think it's an actual conflict because I've got the potential of being an actual witness in the matter that has been submitted, because I know what the facts are of certain things, and I'm an actual witness. Some of the documents that were submitted are handwritten documents from trial. They're on the back side of handwritten documents from trial. I'm an actual witness to many things that are discussed either in the trial with the handwritten notes and questions that were asked and so on. So I don't know how I can, when there's a possible allegation of professional misconduct, because that would certainly be professional misconduct if I somehow took an envelope from Ms. Kurczewski and knowingly delivered it to somebody, knowing that there was a request that that person commit a violation of the law. That would be illegal and a professional misconduct. So that's why I'm asking, I believe withdrawal is mandatory.
Now, I know in your motion, you cited the permissive provision of the rules of professional responsibility under 20:1.16 sub B, indicating that there would not be actual prejudice because Attorney Galaviz would remain on. And obviously, he's now filed a motion himself.
Right, and so at this point, I would cite to 20:1.16A. 1.
Are you aware of any filing or request that any Office of Lawyer Regulation look into any of the conduct that's described in the filing from the state, this 37-page filing?
I haven't been contacted by the Office of Lawyer Regulation at this point in time.
Before I turn to Attorney Galaviz to get his take on some of this, I need to know from the state, you take great pains into, kind of painting this picture that you're no way, putting anything on any of these attorneys. I very clearly understand the state's position in terms of who you think wrote this, but this filing leaves a lot of questions for the court. I don't know how this person who turned this over, I don't know who it is. I know there's some names on it. I don't know if that's the actual individuals. I don't know if you're doing, or if law enforcement is investigating this for any potential criminal violations, whether it's a conspiracy or anything like that. Or so I need a little bit more information from the state as to, how this information was turned over to authorities, and then how it came to the court.
Thank you.
Okay, so my first thought when I heard Judge Dorow say, I know like the state isn't saying anything against Attorney Kugler, I thought, yet it's the state. I mean, I don't blame her. I'd run Attorney Kugler, run Attorney Galaviz. I would run away as fast as I possibly could from Jessy Kurczewski and this whole entire thing. Because I don't know that the state would go after these guys are public defenders. I don't know that they would go after them, but I don't know that they wouldn't because they're the state. So I get it. I would be super, like, there would be a fortress of protection around me if I was either one of those attorneys and this was happening. I would want off of this so fast. I wouldn't even care. Whatever. I'm saving myself. I'm jumping ship. See you later. I'm not going down with you, Jessy. So, yeah, that was my first thought before I ever even, when she said that. Well, the state's not coming after you, Attorney Kugler. Like, that they still could.
Your Honor, and I'll just give a full recitation of how the state came to be in possession of these documents. On Monday, November 27th, Detective Plennis emailed the state's 3 prosecutors here and notified us of this document that was dropped off at the Sheriff's Department approximately 3:00 a.m. on that Sunday, November 26th. It was dropped off by the person whose name was on the receiving part of the folder, who we've redacted. It is a woman who Detective Plennis has spoken to and has learned that that person served at least a brief amount of time in the Waukesha County Jail with Ms. Kurczewski. We believe that individual was present for at least one day, if not more than one day, of the trial here. who had visits at the jail with Ms. Kurczewski by video, not in-person contacts, and had phone contacts with Ms. Kurczewski through Ms. Kurczewski's jail phone calls. So that individual basically was a person who was trying to support Ms. Kurczewski, and so far as she knew what it was to be a criminal defendant and know what it was to either not have a great deal of support or need support, and wanted to support Ms. Kurczewski while the trial was going on. She came home on the 25th of November, that Saturday, and was informed that this package had been dropped off with her. She has apparently a service through the mail where she was able to determine it was not delivered by the Postal Service, but somebody dropped it off in the envelope that Your Honor has seen. We took note, obviously, with that story that the envelope, though it does have 2 stamps on it, not counting the Waukesha County Jail stamp, there are no Postal Service markings over those stamps, as you would typically see if it went through the post office. She began reading through the documents, became very concerned, was not sure what to do with them. She contacted her attorney from her previous criminal cases, who advised her to turn them into the Sheriff's Department. Detective Plentis was notified, I believe, early on that Sunday morning that these had been received, and of course he notified us, as I mentioned before. There is an ongoing investigation into how these materials came from the jail and became delivered. We don't know. I think it's fair to say we don't believe the allegation in the, I'll call it, cover letter of these 37 pages that this was one of the attorney's ideas. I believe that's another red herring or untruth by Ms. Kurczewski is our position. I can say with certainty that the attorneys themselves are not under investigation. There is an investigation into trying to figure out how these documents came from the jail without going through the U.S. Post Office and came to be at the recipient's address. That's the extent of what we know at this time.
I mean, in looking at these documents, I noticed there was no postmark. There's a stamp on an envelope that says this letter has been mailed from Waukesha County Jail with a date stamp. I don't know if you've been able to look at that to know if that's a legitimate way that they stamp it.
I'm sorry to cut you. That is a legitimate way the jail stamps envelopes. One thing the detectives are looking into is whether that came from within the jail. It is possible, perhaps, that somebody ordered a stamp to look like that. Detective Plentis did confirm that this envelope did not go through the Postal Service by talking to the postmaster, I believe. One other thing I'll point out is that envelope that it was received in was folded in half. There was a crease down the middle of it, while the paperwork inside of it was not creased, which would perhaps indicate that the envelope itself may have been included in a mailing, and that papers were put into it later. That's a possibility.
And just to, I guess, summarize, because these were some of the questions that I thought were important to my determination.
I don't think the judge has her mic on because the attorneys seem loud. But I will say this. In court, we saw Jessy's mother. I do not believe her hands are clean in this situation at all. It would not surprise me if the stuff was sent to her mom or given to her mom or whatever, and then put into that envelope, because why would one be creased and the other one not? So that doesn't look good. Her mother is in court. She's sitting behind Attorney Kugler. She has the glasses on and she looks stone-faced and cold and emotionless. And maybe should be scared that she might be coming next for this stuff, because I don't know. They got the big fish, but I don't think her hands are clean at all. It won't surprise me if through their investigation that we finally hear back that her mother was involved.
Here today, the individual whose name that I saw unredacted in the original evidence, shall we say, that came over to me this morning, that has been identified as the actual person who received it, with connections to Ms. Kurczewski, and may have in fact attended the trial on one or more days.
Yes.
Don't know how the information got to her other than it was dropped off, or how the information that the 37 pages left the jail, if it did at all.
Correct.
Is it the state's position that there is no conflict of interest based upon the contents of this letter?
Yes. My position is that if this were to create a mandatory withdrawal because of the conflict of interest, then why wouldn't anybody who doesn't like their attorney anymore simply accuse them of wrongdoing? right? They could easily come into court and say, my lawyer told me to lie on the stand, and so I get a new attorney now. It would be too simple. There's nothing, this is a baseless one-liner in 37 pages that says one of my attorneys came up with this idea. I'm paraphrasing. But there's no evidence behind that. And I do think it's important to know what I noted in my moving papers, that Ms. Kurczewski has absolutely denied being the one to write this. So as far as representing her at this point, it's my position that the defense team need only put that forth to the court that says, you shouldn't consider these because my client says she didn't write them. And the court can decide whether you consider them or not. Obviously, we have a very different position on what these are and who authored them, but that's Ms. Kurczewski's position. I think this would all be different if Ms. Kurczewski said, yeah, I wrote it, and one of my attorneys did tell me. That would absolutely be a conflict. But right now, there's no conflict presented because she's saying she didn't write them. And so it doesn't put the attorneys in a bind where they have to defend themselves. It doesn't put them in a position where they have to implicate her to save their ethical considerations. There's a very easy way that I've put forth already that they can zealously defend her by putting forth her own position on this pile of letters.
Attorney Galaviz, I'll turn to you next and ask you if you can provide some specificity as to what ethical rules do you believe are being implicated by this, and what is the actual conflict of interest based on this filing?
Judge, all I can tell you is I looked at the filing by the state, document 567, contacted the state bar ethics, ran it by them, they said I should withdraw the case. That's all I'm going to say.
I like how Jesse's, no, you can say this too. You're not a lawyer, Jessy. Shush.
When I look at SCR 20:1.16 that deals with declining or terminating representation, there is a section of that under a little bit kind of odd how it's numbered, but there's a small a at the beginning, and then subs 1, 2, 3, and then under 3, there's in parentheses a B, which I believe is the provision for which both of you are seeking to withdraw, that states, except as stated in paragraph sub C, a lawyer may withdraw from representing a client if, 1, withdrawal can be accomplished without material adverse effect on the interest of the client. 2, the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. 3, the client has used the lawyer's services to perpetuate a crime or fraud. 4, the client insists upon taking action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. And if you look further down, there's an or. So it's not that all of these things need to be shown, it's an or. I mean, I don't have the benefit of knowing the basis for what you think is the conflict, other than there's this letter. It says not so nice things, but that's all. I have a denial, apparently, at least what the state is saying, that your client denies writing this. I mean, I could come up with a lot of scenarios where, obviously many people watch this trial. Anyone could take notes. I took time looking through all of this filing, and I think there might be some circumstantial evidence, if you will, that perhaps Jessy Kurczewski is the author. There's content, there are the trial notes, there's other things, but I don't know that anyone can definitively say that at this point in time. I don't even know if I should even consider this. I mean, that's one of the things. If I simply say, I'm striking this from the record, I will not consider it based upon the uncertainty and the ongoing investigation, how is there any conflict of interest?
May I speak?
No, not yet. You are still
That was-
represented by counsel. And
that
you
was
need to
Jessy.
talk to them first. No, hold on.
Judge, some of those papers in there have our handwritten notes on them. We know our own writing,
Well, I don't know that, do I?
but well, I'm telling you now.
But see, that's where an affidavit would have been really, really helpful. Could have been filed under seal. Could have given me more information and avoid what I'm doing here in court on the record.
Understood. We recognize some of our own notes from trial.
All right, so you believe at least a part of that filing that has what appear to be trial notes were contemporaneously done during the trial, and you recognize your own handwriting on some of it.
Yes.
All right. I've taken a look at also the confidentiality requirements that are applicable to both of you. There are some limited exceptions to what I would term as the confidentiality requirements between an attorney and a client. Some fall under a shall and some fall under a may. And even if I look under, and it's the SCR 20:1.6, says sub C, a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary. Sub 1 does not apply. There's not death or substantial bodily harm that you would be preventing. You wouldn't be preventing, mitigating, or rectifying substantial injury to another person. But here's where I think you could potentially be required, or at least asked to reveal, when it would be to prevent, mitigate, or rectify substantial injury to the financial interest or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud in furtherance of which the client has used the lawyer's services. Even if you believe there's some unwitting use of your services, the fact that part of these crimes for which your client now stands convicted involves theft from the estate and there's a pending probate case, I think one could argue that what's in this letter, if true, because I think for purposes of the motion, I have to assume that it's true. I don't think I'm going to give you all the benefit. It's just for purposes of the withdrawal, Ms. Kurczewski, right? Your attorneys have asked to withdraw. I have to base it on some facts. And hold on.
I haven't had representation in the last week, though, and I need to be able to
Ms.
speak to that.
Kurczewski, now is not the time. You will be given
She
an
just
opportunity.
Doesn't
But I
get
need
it.
to have facts upon which this decision of mine, which is a very important decision, be made. Counsel and defendants oftentimes have a disagreement on strategy. Relationships fall apart. That does not always mean that attorneys are allowed to withdraw. Because as Attorney Sitzberger has pointed out, it would be so simple and it'd lead to absurd results if every time a defendant raised an allegation, whether it be an ethics complaint or criminal activity, if that were enough, we'd never have criminal defense attorneys, right? So there has to be something more. I'm concerned in this case because of the fact there's not a postmark on this envelope. And I'm concerned that there is an ongoing investigation as to whether it came from the jail, whether it came from you or someone else. There's other things it could be. Like I said, there's, a lot of people watch the trial. I now know that your attorneys recognize their own handwriting. That's very concerning to the court because very few people would have had access to that. And I have to be concerned with the integrity of these proceedings as well. I read the cases that the that the defense cited, and in particular, State versus Miller. There's a difference when ineffective assistance of counsel and a conflict of interest is raised in a post-conviction proceeding, and what a defendant or an attorney, or even in the Miller case, there's a discussion of when the state raises a concern with counsel. And that in that circumstance, which is really not what we're dealing with here, that it can't just be fabricated to get counsel off of the case when there's an adversary that the state might think is formidable. That's what it's talked about in that case. But this is raised prior to sentencing. And I believe the case law is pretty darn clear that if I can find there's an actual conflict of interest or a serious potential conflict of interest, then I have to presume there's prejudice. That means I create a situation, if I make all of those findings, that cast doubt on the entire sentencing hearing if I force attorneys Kukler and Galavis to stay on. That's what we're dealing with right here. And for everyone, the court now, I'm right here with everyone. Is it frustrating? Absolutely. Do I want to get this case concluded? Absolutely. Do I want to give Ms. Kurczewski the opportunity to file her appeal, which presumably will follow and raise issues? Absolutely. I'm well aware there's rulings you will absolutely want to appeal that I made, one of which is the jury instructions. I get that. And for the victim, there needs to be finality as well. But it does no one any good if I ignore all of this, simply plow forward, and then have to redo it at a later point in time. I'm a big believer, right? Let's do things right the first time to avoid that appeal, or at least that particular issue. And I think there's an argument that if I ignore all of this and later on a court of appeals or Supreme Court says this was an actual conflict of interest, or one at least that rises to the level of being a serious potential conflict of interest, then that would likely be the remedy, assuming all other issues, would be affirmed. So I'm mindful of that as well. This weighs heavily on me. I've spent a lot of time looking at it. I've looked at the various ethical provisions. And while I agree with the state that it can't be just an allegation from a disgruntled or desperate defendant, generally speaking, there has to be
I'm
something
not
more.
calling you that, Jesse.
It is important, Ms. Kurczewski, that I know your position on all of this as well, because also in the case law, there's a recognition that even with an appointed attorney, if this is who you want to continue representation, that matters as well. And I don't know your position, so I'll ask you, I don't want you to comment on anything else. Merely, do you want either Attorney Galaviz or Attorney Kugler to represent you at sentencing?
I did. I do not, because up until yesterday, neither one has done anything for me now because they had halted all proceedings due to the DA conversation they have had. So at this point, as much as I wanted to get out of Waukesha County and proceed forward and go through appeals, I don't, because nothing has been done for sentencing except last minute yesterday, partial. I have letters of character in limbo. I have nothing completed for sentencing, so no, I don't, and I frankly blame the state for that. They proceeded to release this information, which should have not been done, and it has created this mess. So while they are requesting they should not withdraw on their behalf, I don't think this is right. Everything has been done wrong since they have came forward last week with this information. And I do say, no, I did not write it. There's cameras all over this jail. There's recorded phone calls. There's a lot of issues here that, no, everything should be stopped. And I need to look at my legal rights because I don't know what they are at this point.
I can
Moving
tell you,
forward, no, I do not think because of everything that I have since learned, no, I should not have either attorney, which is very hard, proceed at this point, and sentencing should be stopped today.
I can advise you that even if I require them to stay on, I would not go forward with sentencing today because I'm mindful that there has been a pause.
Yeah.
And so knowing that if I were to keep them on, I would adjourn sentencing to give them time to prepare. Does that change your position in any way?
No, I don't think either one of them feel comfortable staying on, so I would prefer not to at this point because of the conversation or little of conversation I've had with both of them. I would prefer not to, no.
Do you understand that could be a significant delay?
Unfortunately, yes, I do. And that is more upsetting, and that is on the state at this point. They released this information. They made this mess.
Jesse and her perpetual victimhood gets so old. No, Jesse, you made this mess. You did this. Your actions, your theft, your Visine, your stories, your forgeries, everything that you did made this mess that you are sitting in right now. And when I saw the contents of part of the contents of what you, what's allegedly from you, it seems to be from you. It seems to be your MO. Here's the script. Here's what to say as Lynn. Here, next, here's how to forge a document that has Lynn stating that she did this to her mother and couldn't live with that guilt, so she did it to herself, and get it notarized so that it looks to be prior to Lynn's passing. That is straight up you. That is straight up what we saw in court. I don't feel bad for you. I was on the fence. I mean, I was kind of falling off towards the side that she did it, but I was on the fence until I read that. And then I'm like, yep, nope, you dummy. This is not the state's fault. This is your fault. And you will never take responsibility for what you did. I think you will sit in prison and be one of those, I'm innocent. I did nothing. People that aren't. There are innocent people in prison, and I hate that. But I don't think she's one of them when she finally
It
gets
should
there.
have been stopped, but they did this. And that is, quite frankly, very frustrating. And they have no way to blame but themselves right now. And it is very frustrating. It is very frustrating. And I was told walking out of the detective's office last week, just so you know, you probably will not be leaving anytime soon because of this, knowing I wanted to leave. I have not told them I did not write these letters. So again, that is coming from what? My phone calls? My conversations?
All right,
I did not.
We should,
it's
I'm gonna
very
advise you at this
frustrating.
point that I've heard your position. You should consult with an attorney
I would love to. I still have two on
before
record and nobody will
making any
talk to me.
further statements.
I've been trying all week. And I have tried, I have a letter for you that I have tried to get through the jail, but I will not send it anywhere because I don't trust putting anything out there. So I have had a letter since Sunday for you. I couldn't send it. I have it with me today. Obviously, I
I'll
don't
accept
your
that
email.
filing today if you would like to provide it, and it will be uploaded and e-filed, and it will be part of the record.
That is completely fine.
Attorney Sitzberger, I want to turn back to you because
Well, I'm glad you
the state has
agree
made
with the
this
judge.
request that I consider
I don't think she cares.
37-page document, presumably because you believe it is relevant to sentencing, I guess, on the character of Ms. Kurczewski. Would I be wrong in that assumption?
No, Your Honor, and I would say that we didn't release anything. We filed appropriate documents with the court when they came to our attention that directly go in our position to Ms. Kurczewski's character, and we are duty-bound to inform the court of everything that's relevant to sentencing, which, as this court knows, character is at least 1/3 of the equation. So we filed those. We tried to give the defense attorneys ample leeway in seeing those and offered them to see the originals before we filed them with the court. That's
But you
all we've
make
done.
some, I would say, assumptions in your letter that these are written by Ms. Kurczewski and, you know, some of the facts and circumstances surrounding that. I mean, from my perspective, there's an allegation that she is the author of the documents and that somehow they made its way to a person with whom she has some connection. I mean, at this point, I mean, it's not like I can simply undo the filing. I know I referenced that earlier, and, you know, does that solve the issue? Does that remedy if I simply say, I'm not going to consider it? I don't think it does that given the nature of the filing. But the flip side to that is, why wouldn't the state want more information about it so that at the time of sentencing, if I allow it, it's more accurate? Why wouldn't I want your investigation to conclude?
In a perfect world, we'd all want that, Judge, but we're trying to balance a lot of interests here, as the court is. We know that everybody involved in this case, the defense included, has been going through this case for 5 years now. The court case itself, probably 2. The trial was long. So there is an interest in finality, obviously, especially to the victims and the victims' loved ones. We file things and we may never know the answer to some of these things. Now, perhaps time will reveal some more answers, but I can say with certainty that the detectives have been looking into this, I would say, on a daily basis, trying to figure out that gap in time. How did they, right, and it's our position. The letter I filed was to put forth the state's position on these things, knowing that the defense would have an opportunity, and that's why we asked them to look at the originals ahead of time so that they could be prepared to file their position with the court. I think that's what the state does in a great many filings. In criminal complaints, for example, we put forth what we believe the evidence shows. Of course, there are allegations, and I can't prove this beyond a reasonable doubt at this point that Ms. Kurczewski wrote. I can say that it came to our attention. We wanted to give the court ample time to review these documents. We were not just going to assume that at the time we filed these, sentencing would be adjourned automatically. So we've given the court a week with these documents from our filing date. And the detectives have been working hard to answer all of those questions the court has, and frankly, the state has, and I'm sure the defense has. We just haven't been able to solve some of those answers. But we thought it certainly relevant that these were written on the back of trial notes, that they're dated, that they're made to look like certain pieces of evidence the state put forth as fraudulent during trial. Obviously, they're not those items because they were written on the back of trial notes. The letter purports to be from Jessy. She signs her name. I'm no handwriting expert, but the writing looked similar to what we had seen from her handwriting. And she's the only one to gain from having somebody file the things that are requested, a tape recording of Lynn Hernan admitting to being suicidal and essentially putting together a suicide tape and sent to your honor from a concerned citizen with no return address. The envelope itself,
And why wouldn't you send it during trial? So for those of you not, I just lost my mind today. If you're not familiar with this trial, the state actually didn't call her. The defense did. A handwriting expert from the FBI come in to talk about the handwriting samples that Jessy did. But the state pretty much used her to their advantage because there wasn't any way to really eliminate Jessy from being She couldn't 100% say some things were Jessy or not Jessy, but she couldn't eliminate her. Doesn't look good. She could, she could be like, yes, this is Lynn. Yes, this is Jessy. And then on some things, it was kind of like, some of this looks like Lynn, some of it looks like Jessy. So if you're trying to tip that scale, it doesn't look good. And so when you talk about handwriting samples, if they're not constantly the same, Jessy's really good at it. She's really good. So we saw her work during the trial. So what he's saying right now, it's you can't argue it.
The return address portion is a person we know to be very good friends with Ms. Kurczewski. And we've, of course, redacted her name and address so it doesn't get out there inappropriately. But that's not something we believe a great many people that could have just picked up Ms. Kurczewski's trial notes would know and even know to include as the return sender. Now, detectives have gone and talked to that individual, and she claims to know nothing about this at all. So we may be left with no answers. At this point, we don't have them, and I don't know that I don't know what percent likelihood I can put on it. I know Detective Plennis informed me today that he's had hours upon hours of jail camera footage put onto a hard drive. I believe it's taken up quite a bit of a hard drive so that it can continue to be reviewed to see if that lends any clues. But knowing that sentencing was today, it was absolutely filed so that this wasn't a last second request for the court to review 37 pages and spring it on everybody as to what the state thought this was. I thought it fair to everybody to put forth the state's position along with the documents itself, along with the opportunity to review the originals because they were double-sided and a single-sided copy. It took the prosecutor team a little time to figure out a single-sided copy on what we were looking at until Detective Plennis had time to sit down and show us the originals. So we first offered that to the defense team before filing with the court with what I would call a guide as to how to read it, given that we could not just bring over the originals to your honor ex parte and show you them.
Have you had an opportunity to discuss the motion to withdraw with the victim?
We have. Our victim witness advocate has been keeping them informed really over the past week as all these filings have come in.
Do they have, does Mr. Posa have, because of the count 3, does he have a position on this or wish to address the court in any way in compliance with victim rights?
Okay, so that's Anthony Posa. He was the other person that, so Lynn left her estate to Jessy and to him. She had no children of her own. She didn't have anybody that would have survived her. So he basically got nothing because Jessy took it all. So I think there's still some things going on, but he's really not going to walk out with, I don't think there's anything for him to get because Jessy took it and spent it. So that's why they're talking about him. He's count 3. He's the, I don't even remember what that count was, but they had his attorney come in. She's an estate attorney, and she was pretty good. She had documents that Jessy had forged, making receipts for things. That then they called like the other person in from the company that she forged. It was like a carpet cleaning service, and he said that's not even what our stuff looks like, and she's nowhere in our system. It was good. It was a good attempt, but when you saw his actual receipts and her receipt, it wasn't good. So yeah, that poor guy, he got screwed. She took pretty much everything, and he was supposed to get stuff, and he got nothing. And let me know if I need to slow them down. The judge speaks really slow, but the attorneys seem to be speaking kind of fast. So if I need to slow them down, I will.
Your Honor, I've confirmed with Mr. Posa, who's present in the court, that he does not wish to address the court, but he's obviously very opposed to this. He's been opposed to a great many of the continuances in this trial, understanding that a lot of them are necessary, but certainly there's a great interest in finality to this case.
Attorney Kukler, I'll ask this to both you and Attorney Galaviz, but I want to make clear that I understand the basis for your request is you believe that or let me state it this way, your request is made under SCR 20:1.6 sub, that's parenthetical B. Is that, do I understand your request correctly?
Yes,
And without divulging confidential information, you have made that request because you believe there's an actual conflict of interest here.
I do. I believe that. And you know, this court knows me from many years of practice and know that I rarely, if ever, have withdrawn from a case.
Thank you. Attorney Gallavy, same question or questions to you. Your request is under SCR 20:1.16 parenthetical B.
Correct, and A, I mean, the state bar ethics told me to cite A as the reason, but B could also be used. It's an obvious conflict.
You have cited actually A and B, and you did, as your motion states, you did consult with the ethics individuals at the state bar,
Correct,
and they made a recommendation to you.
correct.
Attorney Kukla, did you do anything like that, or did you rely upon what Attorney Gallavy's had done?
That's right. I relied upon what he did.
These types of motions are always difficult for the court, especially when the court has not only presided over what was a trial that lasted almost 4 weeks, many motion hearings, significant motions related to the experts in this case, and a case such as this where we don't really have any more significant crime than the crime of first-degree intentional homicide. And it's difficult because, like I said earlier, I don't want to set a precedent that simply leads someone to believe that you make an allegation against an attorney and that's enough to get that attorney off the case. Oftentimes, when we're in the beginning stages of litigation, there's a little bit more leniency when it comes to these types of issues, and this is, I can't say unique, but the circumstances here are important to note that there has been a trial and a significant trial and significant litigation for a very serious crime, and in fact, more than one crime for which Ms. Kurczewski has now been convicted. And lawyers, all lawyers have, in addition to their obligations, for example, for a defense attorney to their client, but all lawyers have the responsibility to be truthful with the tribunal, to have candor. And then, of course, there's all of these confidentiality requirements that apply to Attorney Kukler and Attorney Gallavy's. And there's very, very limited circumstances that a lawyer is obligated to reveal information and then even permissively required to reveal information. And I mentioned this earlier, and I took a look at that, and I honestly think when you look at it, it's really a stretch. I know I mentioned it, kind of to ask a probing question. It's kind of a stretch, though, to say that there's any requirement or even permissively that allows Attorneys Kukler and Gallavy's to reveal information. They're officers of the court. They believe that they have an actual conflict of interest, and they've asked to withdraw. I know from my review of the Supreme Court rules that part of the ethical considerations aren't only to maintain that confidentiality, but obviously lawyers may not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent. But a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. And so, I'm mindful of that. I'm mindful of the rule that's been cited, which is why I asked for confirmation from the lawyers. SCR 20:1.16, terminating representation, sub A states that, except as stated in paragraph sub C, a lawyer shall not represent a client, or where representation has commenced, shall withdraw from the representation of a client if the representation will result in a violation of the rules of professional conduct or other law. Sub B, again, except as stated in paragraph C, a lawyer may withdraw from representing a client if the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. the client has used the lawyer's services to perpetuate a crime or fraud, or 4, the client insists, sub 4, even though it's not the 4th one I've read, the client insists upon taking action that the lawyer considers repugnant or which the lawyer has a fundamental disagreement. I'm also mindful of what this filing actually contains. And when I reviewed it, it's not just a single reference to the attorneys, but on page 2 of what I would call kind of the cover letter to this document, states as follows: even this envelope didn't go out through jail mail. My attorney took it. This was one of my attorney's ideas, and clearly they aren't going to tell anyone. On the second page, which is the 3rd page of that cover letter, but the next page after that, it says, we are trying to make a stir, a big stir, to show just how wrong they are. Again, very general.
And that's just typical Jessy.
Those
It just
are
sounds like her.
The references, I guess, to counsel. This filing clearly raises a concern for the court because whomever wrote it, and I think I do need to consider for purposes of this hearing that one possibility is Ms. Kurczewski is requesting another person to engage in fraudulent and likely criminal activity related to the fabrication of evidence. It's been provided by the state as a request that I consider it at the time of sentencing under my authority and the criteria that I am obligated to consider, right? The 3 primary sentencing consideration, the galleon factors, one of which is the character of the defendant. That's why the state has presented this information. This information, though, it presents many more questions at times than answers, some of which we've already discussed, including the fact that there is no postmark over the postage. There is what appears to be a stamp from the Waukesha County Jail. I'm now told, and I didn't, I guess, catch this during my review, is that envelope has a crease in it, whereas in all the other documents within it do not. There is information within that filing, as has been explained here today, where there's a verification that they are contemporaneous notes. Attorney Kukler indicated she recognized either her own or Attorney Galavi's handwriting on it, so there's some legitimacy as to how, or when I should say, that was part of this exhibit or this document was created, right, contemporaneously with the trial or during the trial. When I consider all of that, I think I am left with the inescapable and unenviable decision here today to make a finding that at a minimum there's a serious potential conflict of interest, perhaps even an actual conflict of interest. Looking at the authority in State versus Miller, this court must presume prejudice to Ms. Kurczewski in requiring her attorneys to represent her going further. She does not have an objection. I think there's an additional basis that there has now been a serious breakdown of communication and a difference of objectives between Ms. Kurczewski and her counsel, that this is a relationship that cannot be mended. And even though it means that this sentencing hearing must be adjourned and that new counsel be provided for Ms. Kurczewski, I am going to grant with reluctance, but I think it's the right thing to do, the motions to withdraw by attorneys Kukler and Galaviz. Rather than reset a sentencing hearing today, knowing that this was a very lengthy trial for which transcripts may very well need to be obtained, and or new counsel review the live stream recordings that are available online of the trial itself, certainly talk with Ms. Kurczewski, maybe even talk with attorneys Kukler and Galaviz at a minimum, get all discovery information from them, and last but not least, to give the state an opportunity to fully investigate this issue and present more accurate information to the court at the time of sentencing. I do believe it relates to a legitimate sentencing consideration, but as it states right now, this filing, I think, presents some more questions than answers, and I think more time also gives the state an opportunity. I have to be mindful that both sides have the right to a fair hearing at sentencing. And it would likewise be unfair, I think, to the state if I simply said this isn't coming in as well. I will let them argue it, present it, and any additional information on it at the time of sentencing. New counsel can certainly object, and it, of course, will be up to the court at the time of sentencing to put whatever weight, if any, on that as I consider which or how to impose sentence on Ms. Kurczewski for all of these offenses. Given that it is early December, and we have some holidays coming up, given that it may take some time for the Public Defender's Office to appoint, because she does qualify and will continue to qualify, I will set this over to early January for status of counsel. I believe, Attorney Kukler, you filed a proposed order. Attorney Galaviz, did you file one as well?
Yes, Judge.
All right, then those both should be on my dashboard. I'll look for those, I'll sign them, and that will then trigger the Public Defender's Office. Attorneys Kukler and Galaviz, what I ask is that you cooperate with whomever is appointed and work with them at getting all discovery to them, and all information and notes that you have from trial to that attorney or attorneys, if that's the case, and do that as promptly and efficiently as possible so that there can be the fewest delays going forward.
Yes, Judge.
For purposes of the next hearing, although I'm allowing you to withdraw, if discovery has not been turned over to successor counsel, I'm requiring both of you to come to that next hearing with discovery that you have, just in the event it didn't take place. It's my way of enforcing that.
We will send ours electronically to whoever is appointed.
Even including trial notes and things of that nature that you would give to successor counsel.
We have everything ready electronically for.
She's like, we're out.
Then I'll take your word as an officer of the court that that will be done.
are
And that can
out.
probably be done very quickly then. But again, if it for some reason hasn't happened, then one of you at least should be here.
I keep wondering what she's talking to her now old attorney about. Hopefully it's not legal advice. Because I keep saying, no, oh no, I'm not giving you
Everyone be
anything.
available on Friday, January 12th at 10:30 a.m.
All right, got a note there. I don't know if they'll show it or not. It's just status hearing. But we can at
No,
least
it's
get
just
where her sentencing is.
Okay with me?
Yes, that's good.
All right, that will be for status of counsel and for further scheduling. And again, I'll, as soon as we're done here, look at those.
She really
orders
wants to
and
say
let you know if
something.
There's an issue with them, but presumably I'll sign them and we'll go from there. Thank you, everyone. That does conclude the hearing.
Thank you.
Oh, guess she's not gonna let her.
That will be in 10:16.
So, yes, Jesse allegedly wrote that. I am not. Yes, Bree, she does look like a bad busy in a good way. So Jesse, it was also shown in during trial, after she was arrested for staging this scene and for, causing Lynn's passing, and they had the will, supposedly, magically, a new will appeared. And where did it appear? In the Waukesha County Jail, where Jesse was. So, yeah, this is just her. This is her. This is her MO. This is how she operates. And she got away with it for so long that I think she just hasn't got it through her thick skull yet that she's not going to get away with it any longer. You're done. You're done. You're caught. And good try. I'll give you that. A little too late. I don't know what she thought was going to happen. That they were going to read this letter and be like, oh, we got the wrong person. We did it all wrong. All our evidence sucks. Guess it was wrong. The stories, just the things that Jessy told in her police interviews that she just kept repeatedly going back, because in her mind, I believe that she's just so smart that she had it figured out. This is going to be the thing. This is going to be the thing. And it was never the thing. She was digging her hole deeper and deeper and deeper and deeper. They were just looking at her like, okay, come in and keep talking. She even went so far as to send the police on a wild goose chase, saying that she had taken Visine bottles and wrote a date on them, had taken something else of Lynn's. I don't remember what it was. Oh, a gun of Lynn's, and buried it in a park behind an apartment where she used to live as a child. And then I believe her mother had moved back there in the last few years, or, around the time that all this stuff was going on. So she tells the detective, the one that was sitting behind the prosecutor that was talking with the great big beard, she tells him that this is buried in the park. I mean, they went and looked for it. I'll give them that. Of course, they didn't find anything. So she said, well, maybe it's down a little bit further this way or that way or whatever. So they go look again. And of course, they don't find anything. So she's ridiculous. And I don't even remember what they said to her, that she just, broke out, just crying her eyes out. And then was able to just go, yeah, well, and I mean, it was like, come on, Jessy. If you're crying as hard as you were just acting like you were crying, you cannot just all of a sudden go, yes, and I know. you just can't do it. So I wasn't sure if she was going to let these attorneys off. I'm glad for the attorney she did, because if I was them, I would want to run away as far and as fast as I could. I do have, so you saw Jessy. Kim, I see you missed some of this. So I don't know if you saw Jessy speak, but Jessy interrupted the judge twice, at least. And then wanted, the judge gave her a chance to speak. But old Jessy did a telephone interview the night before, I think it was the night before the sentencing was supposed to take place. So I'm going to play that real quick. It's very short, but, just listen to what Jessy has to say in it, and because I don't believe you, Jessy. I just don't believe you. If my attorneys gave me advice not to speak, I wouldn't. I don't believe her that if she wanted to speak that bad, that when the judge asked her, and the judge did ask her, and she did say, yeah, it was a hard decision, which I get, fine, whatever. I don't believe her that if she really wanted to tell her story, that she wouldn't have said, yeah, judge, I want to speak, even though I've been advised maybe I shouldn't, because it's at the end of the day, they tell you it's your decision and yours alone. And Jessy doesn't seem to, she does whatever she wants to do. She's kind of proven that. So let's play this real quick, and then we will call it good. So this is on TMJ4, which is a local station up there in Wisconsin. There we go. I had to get it to, stop the spinny thing.
It's the night.
All right. Oops. Let me get it over here. Oh. Judge Dorow, stop spinning, is very by the book. I would not want her to yell at me, because she could say all the things I did wrong, the statute, that statute, whatever. You broke 80206 point B, subletter C and D. I don't think she, come on, has very many, I don't think she has very many appeal issues. And I know she doesn't. That's what her, I think her goal is, which is good. I commend her for it. All right, we'll slow this back down because she was speaking pretty fast. All right, this is old Jessy from jail.
Before her sentencing, where she faces life in prison, and this is the first time we're hearing from Jessy Kurczewski. She says she was forced to be quiet during the trial, but now she wants to share her side of the story.
I don't think that's
Nobody
my
got to know
blurriness.
the Lynn I knew, the Lynn that I was there for with and for daily, the Lynn that was my family that I loved and cared for.
Jessy Kurczewski has a lot to say the night before her sentencing.
I no longer can wait. It is time I speak. I cannot be silent.
Making the call from inside the Waukesha County Jail, Kurczewski reveals why she didn't speak during her high-profile trial.
I chose after many conversations with my attorneys not to take the stand, which I extremely regret.
The Franklin woman was found guilty of killing her friend Lynn Hernan back in 2018 by poisoning her with eye drops. The trial ended last month. Now, 3 weeks later, she's still claiming she's innocent.
Lynn took her own life because she was troubled by what she did to her mom. She said that in her own letters that, again, were in court.
Thursday, Kurczewski is scheduled to be sentenced. However, court documents show her two attorneys have filed a motion to withdraw from the case. Waukesha County Judge Judge Dorow will make a decision on whether they can withdraw ahead of tomorrow's sentencing. If the attorneys are granted their request, that sentencing will likely be pushed back.
Both of my attorneys are still listed on record, so legally I cannot speak to any other attorney, nor will they speak with me. I sit in limbo. I need to know my legal rights.
The 39-year-old is facing life in prison. While Kurczewski waits to hear her fate, she's adamant she didn't kill her friend.
There was so much not allowed to be brought up in trial, so nobody got to hear the real story.
For now, sentencing is still scheduled for 1:30 tomorrow afternoon.
I do not believe for 1 second. If Jessy really, really, really wanted to speak in court, she would have. She would have just said, Judge, I want to speak. The state would have destroyed her. It would not have been a smart move for her. And there was some things. Oh yeah, she said she said quite a bit in her police interviews. You are exactly right. Yes, she did. Holy smokes. She just thought she had it. And then with the fake will, the story about her Lynn and her mother, I mean, it's ridiculous. It just gets to the point of, okay. The one thing they weren't going to bring up in court, they weren't allowed to bring up in court, which eventually the state's own witnesses talked about it so much that the judge is kind of like, you guys have brought it in, was that Lynn was an alcoholic. So there were things in her autopsy that pointed to that. They weren't, for whatever, the state didn't want that in. I'm sure they thought it was not helpful to them, but their witnesses, all their, like the doctors and, everybody that was doing the stuff was talking about Lynn. And every time they got to, I think Lynn had fatty liver disease, which they said could be from alcoholism. It just kept going back to alcohol. So they were able to bring that in. I don't know what else they weren't able to bring in. It's not like we get to see all that kind of stuff. But if I was a betting person, my money would be on she orchestrated this letter campaign. She tried to pull her attorneys into it. Probably thinking that would make the person that she gave the letters to feel a little bit more comfortable about, breaking the law. I just don't get this woman. I don't get her. But I will see if they do the status hearing on January 12th because she's facing life. I think it's mandatory. She's not getting out. So, she just wants to get to her new home, I guess, her forever home. Maybe she'll meet Taylor Shabusiness there. That'd be a scary duo. Yikes. So I think Wednesday I'm going to probably do Sarah Boone. Supposedly, she's coming up next to the beginning of, or the first of the year, supposedly. We'll see. She just keeps, she's another one. She also said a lot in her police interview. So she also said a lot in the body cam footage of the day that it all happened. She just says a lot all the time. She's like Jessy, she wants to speak all the time. So we'll do that Wednesday. Again, I'm just going to do, I plan on just doing short stuff here, short videos till the first of the year because I don't think there's anything coming up. So we'll just kind of do whatever, right? If you have anything you want me to look at, let me know. I have nothing really scheduled. So maybe I'll just get on here and just, I don't know. We'll find some, I'll find something hopefully interesting. So anyway, that's it for that. If you haven't already, please hit that like button, subscribe button. I put my Twitter name on the bottom there if you'd like to follow me on Twitter, because especially on Rumble, will not let me link it over there for some reason. So I cannot. So I just thought, well, I'll just put it underneath my name. I post to Twitter when I'm getting ready to go live. I haven't really posted there much more than that, but I'm going to try. So enjoy your Monday. I hope that my Monday does not continue to go like, you know, pulling the drawer handle off. I hope the rest of my day does not go like that. So you guys enjoy the rest of your day. I will see you Wednesday at 10:30, and we'll do a little Sarah Boone, probably, maybe, unless something else comes up that's more interesting in her. So I don't know. We'll do some Wednesday. So I'll see you then, and have a great rest of your Monday.